We are at real estate contracts. And I believe what you have read in this section is probably a pretty good overview of about what you already know about valid contracts. So what I thought might be helpful, as you've been doing all this reading and all this listening to videos, for those of you that are maybe visual learners, I wanted to show you a sample contract. And I did have it in your link, in a link in the reading for you to click and read this yourself. If you're going to be doing buying practices with the Iowa Real Estate Academy, we cover this during buying practices as well. This is a sample purchase agreement that a buyer will write as an offer to a seller to purchase real estate. This one was created by the Des Moines Area Association of Realtors. We went together as a local board. Most of you that are going to be working probably in residential real estate will not only have your real estate license with the Iowa Real Estate Commission, you'll choose to join a local, state, and national board. And a local board, for example, is the Des Moines Area Association of Realtors. We call it DMAR as an acronym. And then that also, you become a member of Iowa Association of Realtors and National Association of Realtors. This, we went together to create a uniform contract, and most brokers in our community use it. But again, check with your broker about what they want you to use. And if you're outside of this membership in a different membership around the state of Iowa, or you're choosing not to join a membership, that's an option too. I still think this gives you a good basis of what to expect with a purchase agreement, and what you'll be writing for your buyers and what you'll be reviewing for your sellers when offers come in on these properties. One thing I do want to note is I'm not an attorney. My best way to describe this to you is some states are attorney states and some states are non-attorney states when it comes to real estate. And what I mean by that is an attorney state would be a situation where a real estate agent, a licensed agent, could maybe write a letter of intent on behalf of a buyer, or they could set up an escrow and make a deposit. But they would actually need an attorney to even write this contract. Iowa is different than that. I would consider us a non-attorney state when it comes to real estate. And what that means is, as long as we've got this shell of a contract written by an attorney, we as licensed real estate agents can fill it out. Okay. So I don't want to make light of this because it is a legally binding contract. This is not a receipt that you can go and return a shirt that you bought at Von Maur. There is no 3-day right of rescission law that I know some states might have for big purchases. That is not the situation. When this is agreed to upon by a buyer and a seller, everyone signs it, has a copy of it. This is for realsies. But does it help you to know that it's still in the blank a little bit? I hope that gives you a little relief. You don't have to rethink of all of these entities when you're writing an offer. We've got the bases covered for you. But again, it's serious. I'm just going to review some highlights. This is a 5-page document, but I think it'll help you understand that list of elements that go into a contract a little bit better. 16 is the seller's name. You want that written out. You can get that probably from the assessor's page or from information that would be provided through a multiple listing service. Your buyer's name would go on line 17. Line 18, you would put the county and city. Line 19, where it says locally known as, that's where you would put the street address. And make sure that you put 123 Banana Street, Lane, Boulevard, Drive. Don't just write 123 Banana. Line 20 is where it says legally described as, and that's where you're going to do that legal description that we've talked about previously when we were defining real estate kind of at the beginning of your journey. It's going to be something like Plat 3, Lot 7, Western Hills Estates would be an example of a legal description. However, you might have a legal description that's really long and does not fit on this little line. Do not write long on file, per abstract, ask seller. What you would want to do, and this is a great test question maybe too, that could help you navigate through the exam, is if it's too long, refer it to either another section in the purchase agreement where you've got more room, or refer it to an addendum, an additional document that attaches to the contract where it's written out in full. Because remember, that's what legally holds up in court. Line 23 is where you're going to write your purchase price. Line 24 is where you would address earnest money. You can do some with the offer and some upon acceptance. I think a lot of offers turn over earnest money once the offer is accepted. And in most markets that I know in Iowa, the earnest money, that consideration, is held by the listing broker. Okay, so whoever has the property listed, that's who you would write there, not your own personal broker unless they have the property listed. Then you're going to talk about how they're going to pay for it. And most times you're either going to do a new mortgage or cash. If you're doing a new mortgage, you would write the type of mortgage, conventional, FHA, VA, for example, for not more than blank percent. That's where you're going to write loan to value. So if you're doing an FHA loan with 3.5% down, you would write 96.5 here. If you're doing a conventional loan with 10% down, you would write 90% there. Then on to line 30 says, with a note interest at, you're going to write the interest rate there that they've been quoted by their lender. I usually give it a little bit of a pad. So if they're approved for 4.5, I might be right, 4 3/4. But do write a number there. I see a lot of agents that try to write market price or something generic. I want a number there because let's say overnight something crazy happens. They were quoted and pre-approved for 4.5% interest rate. The offer gets approved, and when they go to lock in their mortgage the next day, rates have gone up to 10%. It's probably not going to happen, but for this example, if they would skyrocket like that, it would be a reason to get out of the contract because we can't get the rate we were quoted, and that obviously would greatly impact their house payment. Then we're going to go on to say for a term no less than, this is where you're going to put the length of the loan, which is usually 15 or 30 years. And then item 31 and 32 is where you could ask a seller to pay for part of the seller's closing cost, or sorry, you could ask the seller to pay for part of the buyer's closing costs. That number I often see in the $2,500 to $3,500 range for reference, but again, you would want to get that information from the lender. Then of course, subject to appraisal, if you're getting a mortgage, I would want to check that one. And then it could maybe be subject to closing or subject to sale. Subject to closing means they've already got an offer on the current property they own, but they need it to close in order to buy this one. They can't carry both mortgages. Subject to sale is similar, but the difference is we need to sell the property before we can buy this one. We need to sell the current property before we buy this one, but we don't have a buyer yet. Okay. 65 is closing in possession. That's where you'll write the date you want to close and when the buyer will take possession. I prefer that buyers take possession at the time of closing in an ideal world. Line 89 is where you would discuss that time frame for doing the home inspection. And I'm going to suggest that you read your contract very carefully about how this works. I know a lot of agents think that, well, we'll do the home inspection, and if we don't like the results, we'll walk away. That's not how I read this contract. I read it that you can do the inspection, but you got to give seller notice of the repairs. Then they've got 3 days to respond to you. And then if those steps aren't acceptable, then it says agreement is null and void, earnest money returned to the buyers. So just make sure you read that section very carefully. And by the way, if I haven't said this already, in case I'm repeating myself, if your broker offers any type of forms training about how to fill this out, or listing agreements, seller disclosures, all of these forms, go to it. Learn to write these contracts on their standards. You work for them, not me. I'm just your instructor. So I would really suggest go take a good forms training class if they offer one. A couple of other things I want to point out. Line 120, this is going to ask the seller provide for a termite inspection report. This is line 127, where the buyer could ask the seller to provide a 1-year home warranty. For example, it's a way to cover wear and tear on appliances and mechanicals. You might have a vendor that provides that service in your market. This says special assessments. Now, we've learned about real estate taxes, property taxes, and special assessments. Special assessments, again, are a special tax that is usually created for a special project, like putting in sidewalks or repairing something that just those homeowners that benefit from the improvement are the ones that are going to pay an additional tax for the activity. Property taxes are what you owe on a regular basis just for owning property in your county. And what this says is any special assessments the seller already has or gets through the date of closing, they will be accountable for. Line 135 with property taxes says that they will pay taxes through their date of ownership. Okay, because the taxes might be due either in an accrued or a prepaid fashion. And you'll learn more about that and how to do the math around it in calculations. Line 143 says that the homeowner or the seller will keep the property insured through the date of closing. That way, if there's any damage done to it, we know that they can make the repair. Line 149 says that they will do abstract and title. We're going to talk about title transfers here coming up in the next section, I believe. But this says that they will provide clear title. And then this also talks about how they're going to take title. This one assumes joint tenancy. So if your clients want to do something else like tenants in common, first of all, they should probably consult an attorney, but you would want to make an adjustment. Most people take joint tenancy, okay? And then obviously we go down here to included property. And we cannot write any personal items on here, like couches, pianos, dining room tables. Most lenders allow appliances, stove, microwave, refrigerator, dishwasher, washer, and dryer. Any other personal property needs to go on a bill of sale, and we'll review that again here coming up. So make sure if you intend for those to stay, those get written, for example, on line 96. And then finally, we've been talking about an offer expiring, how an offer can expire. That would be line 225, where we would write a date and time that if the seller does not respond by then, that the offer becomes null and void, and any prepaid payments like earnest money would be immediately returned to the buyer, because we've never had an offer come to fruition with this seller. Obviously, there are signatures involved here. But we talked about rejection. And for some reason, if a seller would reject this offer, they're offended by it or they accepted something else, this is good to make sure that the seller signs rejection so that you can always prove that you did in fact present it, because we must, by Iowa law, present any and all offers. No matter what, you've got to present an offer to your seller. So hopefully that helps to kind of get a visual. I know it was fast, and hopefully you'll be getting a lot more experience with that. But again, I think it's just a good visual presentation, so you've got a little idea of what a contract actually looks like.